All right, I think we're ready. Good morning, Ms. Rivers. Are you able to hear us?
Thank you, Judge. Good morning.
Good morning. Welcome back.
Thank you.
All right, we have a calendar that is primarily pleas, but I think there's an inquiry on here. We'll just go in the order it's published because it looks like we've got some of the right folks in place. Although, is Ms. Wood? Yep, she's on her. There she is. Boom. Ms. Mery is on the call. Do you have a lawyer on the call? Oh, yep, Ms. Brown is on.
Yes.
Great. Ms. Nix, any reason we can't take the two pleas together? McGillicuddy and Mery?
I don't think so, Judge. Put them together.
Okay. Why don't we try to do that? Ms. Wood, do you need a second? Or can we get you and Mr. McGillicuddy up at the podium? So let's do that. It's going to be lots of screens. Ms. Brown, can you turn your camera on?
Stand right here.
I'm
Ms. Nix,
trying. I'm
Okay.
trying to find. I'm trying.
Okay, keep trying. Ms. Nix, are you going to stay right there or go to the witness stand? You can be in either place. I just need to know which.
I'm having I don't have the plea paperwork. I tried to get in touch with that, so I don't know what. I'm sorry, I'm not familiar with your process.
So when we're doing it virtually, there's no paperwork anyone needs to fill out. Ms. Nix will cover all of the defendant's rights in her colloquy with them. So I think you've got what you need as long as you understand the general parameters of whatever the plea is going to be.
I don't.
Oh, I just sent you an email. It's going to be the misdemeanor that we discussed.
Okay. I might have to log back in. For some reason, my phone is locking up. I'm in a different courthouse.
Okay.
So I'm gonna jump back out and jump in to see.
Okay. And take a quick look at the email from Ms. Nix and then plug back in. That'd be great.
Okay, I will.
Thanks.
You want us to hang loose, Judge?
I think she'll be back on real quickly.
Oh, okay.
And
I'll just stay here, Judge.
great. Mr. Wright just moved up one on the calendar for next week.
Oh, goodness.
Because the Miller's going to be a plea. That's the one at the top. Cofield will be a plea. There's this Mystery Adams case from Judge Schwal's courtroom. And then the only other one ahead of Wright was Jones, which is an Ingram case, but her litigation manager just said, that one can't go.
Okay, I'm back.
So there you go. Ms. Brown is back. All right, I'm going to add you to the spotlight and great to see you. Okay. And then let me add Ms. Nix. All right, everyone who needs to see everyone is on the screen. Let's get on the record. This is 23 SC 189972. It's the state versus Mr. McGillicuddy and Ms. Mery. Mr. McGillicuddy is here in court, represented by Ms. Wood, who is standing by his side. Ms. Mery is appearing virtually, which we said is fine. Her lawyer, Ms. Brown, is also appearing virtually from another courthouse. Ms. Mery, do you waive your right to be here in open court?
Yes.
Okay. You also have a right to have Ms. Brown by your side. So if you have questions, you literally could turn to her and ask her. We can accommodate questions because I can move the two of you into a breakout room so you can have a conversation if you need to. But otherwise, Ms. Brown is able to see and hear everything you can see and hear. Okay. Are you comfortable going forward with Ms. Brown where she is, which is not the same place you are?
Yes, sir.
Okay. Both you and Mr. McGillicuddy, if at any point you've got a question about anything, let me know. Or if you can't hear what's going on or something's confusing you, wave your hand, do something to get my attention or your lawyer's attention so we can pause and address what that concern is. In a moment, Ms. Nix is going to put both of you under oath. She has a bunch of questions to ask both of you. She will ask them in sequence. She can decide whether it's Mery first or McGillicuddy first, but she will always say, if the question is, please state your name, she'll say, please state your name, Mr. McGillicuddy, and then you'll answer. And then she'll ask the very same question of Ms. Mery. But that way we can take the pleas simultaneously rather than having to work through it twice. Ms. Nix, are you ready?
Yes, sir.
All right, let's do this.
All right, both of you, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? Start with Mr. McGillicuddy.
Yes, ma'am.
Ms. Mery.
Yes, ma'am.
All right, you can put your hands down. Please state your true, correct, and legal name. Mr. McGillicuddy, you can just always go first and then
Edward McGillicuddy.
Ms. Mery.
Leslie Carol Merca.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
No, ma'am.
How old are you?
49.
45.
How far have you gone in school?
11th grade.
14.
Does that mean some college?
Some college, yes.
Okay.
And a certificate in medical assisting. I don't know what you would call that.
Is English your native or dominant language?
Yes, ma'am.
Yes. Yes, ma'am.
Do you understand that you've been charged with the following offenses? Mr. McGillicuddy, possession of methamphetamine with intent to distribute and possession of drug objects. And Ms. Merca, possession of methamphetamine with intent to distribute, possession of a firearm during commission of a felony, possession of drug objects, and failure to obey stop sign.
Yes, I'm aware.
Ms. Merca,
Yes. Yes, ma'am.
do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your,
Hold on, we need to get Ms. Merca's.
Yes, ma'am.
have you had enough time to speak with your lawyer about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Ms.
Yes,
Merca?
ma'am.
Do you need, Mr. McGillicuddy, do you need more time to discuss the case with your lawyer, Ms. Wood?
I don't believe so, if long as it's what we talked about as far as therefore, I trust her. She's-
Okay. Well, and I want to make this clear, Mr. McGillicuddy, there's not going to be any sudden, haha, you're locked into X or Y or Z. You and Ms. Wood have talked about an expected outcome. If it goes differently than that, we'll have an opportunity to discuss what's different from what you expected. Does that make sense?
Yes.
Okay.
Judge, and I think part of the confusion is when the state says, do you understand what you're charged with, may be different than what he's agreed to plead.
Sure. So Ms. Nix needs to make sure you understand what's in the indictment. But it may well be that what's been negotiated is a reduction of those charges. So you should expect to hear that soon, that ultimately the state is letting you plead to, I'm making this up, I don't know what it is, but maybe to a misdemeanor. So that's still to come. And that's why I said, don't worry, before we're done, I'm going to ask you if you have any questions or if something hasn't gone the way you thought it was going to go. Okay?
Yes, sir.
All right.
And Ms. Merca, do you need more time to discuss the case with your lawyer, Ms. Brown?
I'm good.
Are you satisfied with your lawyer's services, Mr. McGillicuddy?
Yes, ma'am. Oh, sorry.
You first, sir.
Yes, sir. Yes, ma'am.
Okay.
Yes, ma'am. I
Okay.
am.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
No waive.
And do you waive any and all defects in the indictment for purposes of the plea?
We do.
Ms. Brown, do you waive a formal reading of the indictment for purposes of
Yep.
the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Right. Mr. McElligott and
You have to let her ask the question.
Okay.
Mr. McElligott and Miss Markey, do you remember having been arrested on these charges?
Yes, ma'am.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court?
Excuse me.
State recommends that, or the state's offer is that each defendant plead guilty to count 3, which is drug objects, and receive a sentence of 12 months probated. Conditions are to forfeit seized property and submit to alcohol and drug evaluation. Mr. McGillett, do you understand that's the state's negotiated sentence?
Yes, ma'am.
And Ms. Merca,
Yes, yes, ma'am.
do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from a negotiated plea you are expecting today,
Yes. Yes, ma'am.
Judge, I believe Mr. McElligott does not have his final plea rights, but Ms. Merca does.
Correct.
Okay.
So there's a slight difference. Mr. McElligott, today you're entering a plea to a misdemeanor. You have to abide by whatever sentence I give you. Ms. Merca is a little less far along in the process and hasn't had what we call a final plea date. So she could choose to withdraw her plea today if she did not like the sentence I'm going to give her. So you guys are slightly different position, but you and I already had a conversation, might have been about a month ago, when maybe the state's offer was different, but whatever the state's offer was, you said, no, thank you. And I explained to you, great, that's your right. And when I see you next, it'll be for a trial calendar, which is when I saw you next. It was for a trial calendar, but you're now entering a plea. And if I accept your plea, I have to impose a sentence. The most I could sentence you to is 12 months. It's a misdemeanor, but you'll be bound by whatever sentence that is. Do you understand?
Yes, sir.
Okay. Ms. Merca, your situation is slightly different only because you never had your final plea date. We were tracking you down, you were tracking your lawyer down. And when we finally connected, we agreed to have your case continue to move with your co-defendants, but you still have your final plea rights. So the only slight difference in the situation is that if I accept your plea, when I impose a sentence, if it is more severe than what Ms. Brown has negotiated for you, you would have the opportunity to withdraw that sentence. I don't expect to diverge much from what anyone's recommending. You all know much more about the case. I just need to make sure you understand that difference. Do you understand that, Ms. Merca?
Yes, sir.
Okay. Ms. Nix?
Thank you, Judge. Are you on probation or parole anywhere, Mr. McElligott?
Yes, ma'am.
And Ms. Markey?
Yes, I am.
Do you understand that your probation may be revoked based on your entering a guilty plea today? And just for the record, Judge, there is part of the agreement is Mr. McElligott's probation revocation in 16 SC 144316. That will be handled with this case, and I don't think we actually ironed out if it was going to be just time served or.
Can you give me that case number again? 16 SC?
Yes, sir. 16 SC 144316.
Got it. We'll handle that revocation today, and it won't be anything that is more severe than 12 months. Well, I guess it wouldn't involve a revocation involving custodial time unless Mr. McElligott has already spent some time in custody in connection with his arrest in this case way back in 21.
Yes, sir.
Okay, got it.
Okay. Mr. McElligott, did you answer the question of do you understand your probation may be revoked based on your entering a guilty plea?
Yes, ma'am.
Okay. And Ms. Merca?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Yes,
Are you-
ma'am.
Are you a United States citizen?
Yes, ma'am.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Yes, ma'am.
How do you plead to the charge of possession of drug objects in indictment number 23 SC 189972? Mr. McElligott?
Yes, ma'am. Guilty. I'm guilty, ma'am.
Ms. Merka?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Correct. Yes, ma'am.
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that since this is a
Ma'am.
misdemeanor?
Hold on, we got to get the second answer as well.
Sorry, that's my fault.
It's okay. It's okay. Yes, ma'am.
Do you understand that since this is a misdemeanor, you have only 12 months from today to file that habeas corpus petition?
Yes, ma'am.
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about December 29th of 2021, Ms. Merka and Mr. McElligott were driving in a car. Officers conducted a traffic stop on that car for a stop sign violation. Both were acting in a overly nervous way, and so officers called in a canine officer. That canine officer, or the dog actually, alerted to the presence of narcotics in the vehicle. Officers conducted a probable cause search of the vehicle and found methamphetamine near the driver's side where Ms. Merka was sitting, and a glass pipe near where Mr. McElligott was sitting. And this occurred in Fulton County.
So Ms. Merka was the driver?
Yes, sir.
Okay.
And the methamphetamine was in a baggie, and that's what we're counting as the drug objects.
Okay.
Or it could be
Or the
the
pipe.
either one. Judge, Mr. McElligott has several prior felonies, all in Georgia. Looks like 4 forgery charges.
When you say charges, convictions?
Convictions, yes, sir. Two drug charges and in possession of a firearm. Judge, the state's position in that case is that charging him or getting conviction for the methamphetamine could be problematic, and so because it was found in the driver's side, and so the state's decided to offer him to plead just to the possession of the pipe, as it was on his side of the car, and officers noticed he was reaching for the area in which it was found.
Okay.
Miss Merka, I'm sorry. I could not find any convictions prior to this incident. There was another drug arrest in Carroll County in which she pled guilty in February of this year. So it's a subsequent arrest. And the state was provided with evidence that she has attended drug rehab and has been clean since since the Carroll County incident, and has been attending aftercare. And so the state is satisfied that she is addressing the issues that led to this case.
Okay, great. Thank you. I think we have someone on from pretrial services.
Good morning, Anna.
Good morning. How are you?
Good. How are you?
I'm well. Can you share with me what criminal history information you have for Ms. Merka first?
Yes. We have 7 arrest cycles beginning in 1997. We had the 1 felony conviction that was mentioned out of Carroll County for possession of Schedule 4 controlled substance and possession of methamphetamine. Position date on that case is January 11th of 2024, and she received 3 years probation on that case.
7.
Let's see.
Yes.
3. Yep, 7 years. I apologize. So
That's
3
okay.
years on the possession of the Schedule 4, and then 7 years on the possession of methamphetamine and a $500 fine. Last
Okay.
arrest was in Carroll County, March 6th of 2024 for a violation of probation. Nothing to add.
Okay, and on Mr. McGillicuddy's side, how many cycles and how many felony convictions did you find?
We have 32 cycles beginning in 1993 within the last 10 years. He has 3 felony convictions. Most recent felony 2 felony convictions. He has 1 felony conviction out of the state of Florida, and that's from 2017. But I'll go through the most recent for Georgia first. That's for possession of methamphetamine with intent to distribute. Let's see, 1, 2 counts. Possession and use of drug-related objects. Possession of a firearm or knife during the commission of. Position date on that case is November of 2020, and that's out of Fulton County. And he has another felony conviction out of Fulton County for possession of a firearm or knife during the commission of. And that's from 2015. And the 1 felony conviction that's out of Florida is for drug possession of controlled substance without prescription. And that's from February of 2018, Your Honor. Nothing to add.
All right, thank you so much. Officer Evans, good morning.
Good morning, Your Honor.
So
I'm showing that. Oh, I'm sorry.
No, you go ahead. You can start with either one.
For Mr. McGillicuddy, I'm showing that he has 2, 3, 6, 7, 8, 9, 10, 11. A total of 11 felony convictions. I'm showing a 2005 of forgery in the first and a drug charge. And that was November 16th of 2005 out of Douglas County. I'm showing a DeKalb County, July 6, 2006 for violation of the Georgia Controlled Substance Act. I'm showing a 09 SC 77637 sentence November 9th of 2010 for forgery in the first and financial identity fraud felony out of Fulton County.
I've got a good list of those in the repeat offender notice from non-complex. Can you tell me for which cases he is on active probation and then how much time remains on those?
Yes, Your Honor. He is actively on 16 SC 144316. That's set to expire November 15th of 2026. He has 2 years, 2 months, and 6 days remaining and is currently on unsupervised probation at this time.
Got it. And that's the only open case that you see?
Yes, Your Honor.
Okay. Thank you so much. And how about on Ms. Merca's side?
Ms. Merca is on that Carroll County probation as stated, and then I do see a first offender that was successfully completed back in 1997. And that's all I have for her.
Perfect. Thank you so much.
Yes.
All right. Let's start with Mr. McGillicuddy. Ms. Wood.
Thank you, Judge. He's 49 years old. He is from Atlanta. He has a sister here who's very supportive. He is currently gainfully employed with Tactical Productions. He sets up stages for big events. Judge, he has not had any issues since this arrest in 2021. He did spend 49 days in custody, so that's what we will be asking for on the probation revocation side of this matter, Judge. But otherwise, we would ask that you accept the state's recommendation.
All right. Mr. McGillicuddy, do you stay with your sister or you have your own place?
No, I stay with I have my own place.
You have your own place. And this Tactical Productions, how many days a week do you work for them?
4 to 5. It all depends on the season. And as far as like summertime, 5 days a week. Wintertime, it slows down because, events like Lakewood, outdoor concerts and indoor concerts. It all depends. At this current second, I'm not sure if you know the Tabernacle, but we just lost that account. Therefore, that's not my fault. That's my employer's fault. But we're not working as much as I'd like to.
So do you do anything to supplement that, or that's your one job?
That's my one job. Also, I work for Live Nation too. It's the same setup stages.
Yeah.
But I'm mainly employed with Tactical. That's my main job.
Okay.
And now whenever Live Nation sends me an email or something for an event and I can make it to, I take it.
Okay.
So I'm employed for Live Nation as well.
Got it. So you stay busy enough.
I try to.
You try to. Good. All right. Do you have any questions about anything we discussed?
Just no, sir. As long as what me and my lawyer discussed is firm.
Okay. Well, let's see what happens. Mr. McGillicuddy, I find there's a factual basis for your plea that you were in a car with Ms. Merca a long time ago. Drugs in the car. Looks like people were using drugs. So I do think that there's a basis for you to plead guilty to possessing drug paraphernalia. I'll accept that plea. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about, and voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. I'm going to sentence you to 6 months probation on count 3. You will forfeit whatever was seized. My guess is you've long forgotten about what was in that car, but now don't rush down to, what was it, the Atlanta police?
Yes, sir.
Don't rush down to Atlanta police to say, I want that pipe back or anything like that. You've turned the page on that. I will have it be a part of your misdemeanor probation that you submit to a new drug and alcohol abuse evaluation. And if that expert thinks you'd benefit from any treatment, whether going to NA meetings or AA meetings or who knows what, that treatment would become part of your probation. Okay. Now, in addition, in 16 SC 144316, I'm going to revoke 1 month of that probation, but I'm going to give you credit for the time you served. You were locked up on a probation warrant in connection with that case that Judge Glanville, it's a colleague of mine, signed. He signed it back in 2022, but it caught up with you this year, and you were in jail for about 44 days on that warrant until Judge McAfee, who took over Judge Glanville's cases, set that aside and didn't revoke your probation, simply said, I'm going to let the judge who deals with this new case, which would be me, deal with the revocation. So I'm revoking 30 days, but you'll get credit for the time that you served. And I'm going to reinstate that probation, and I'm going to direct probation to make it supervised probation for another year. So you had 2 years and 2 months anyway. It has shifted to unsupervised. But just so we make sure that you are taking seriously whatever treatment, if any treatment is recommended, I'm going to have it be supervised for the next year. but I'm going to set a behavioral incentive date of September 11th, 2025. And what that means is if between now and then there've been no issues, you show up for your meetings, you don't have any positive screens, then probation will ask me to close out that case. Your misdemeanor case will be done by then. That's only 6 months. But a year from now, if everything has been going well, your felony case can be closed out as well. Any questions about any of that?
It sounds so, 1 year, if, everything's, I'm off probation, correct?
Right, correct. But that's on you. It's 1 year of you not using,
Yes, sir.
showing up, not getting arrested. If you get pulled over for running a stop sign, that's going to upset the apple cart. And they're not going to, probation's not going to say after a year, Mr. McGillicuddy was doing fine. So do fine.
Yeah, that sounds great. That's a goal of mine.
Okay. Well, good. Keep up that goal. You have any questions about anything?
No, sir.
Ms. Wood, we'll go over report. Well, I guess we'll see if Ms. Officer Evans has any questions about that.
Thank you.
Okay. All right. Ms. Merka, we're going to turn to you now. And Ms. Brown. Ms. Brown, tell me about your client and what's going on there.
So I've been working with Ms. Merka throughout this case and as well as her Carroll case. She has been taking her sobriety very seriously. She's attended rehab since that time. Additionally, she is on felony probation under a conditional discharge sentence here in Carroll. She's currently participating in the Matrix program with probation, which is like an aftercare situation. It also helps for them to find jobs. She's in the process of getting skills, and she's turned the corner. So we asked that the state accept the negotiated misdemeanor and
Can you say that last thing again? You chopped up at the very end.
She will to give her an opportunity to continue to work on her sobriety, stay in sobriety.
Okay, got it. Ms. Merka, are you working these days?
I'm going to school. I'm taking this class. It's a 7-week program. I just graduated actually Friday, and then we have to take 2 more weeks to actually get our CDL license. So I got my permit. I'm just waiting to take my road test, and it's at Georgia Perimeter. So I'll be, as soon as I've been looking, for CDL jobs, and I got my OSHA 30, and I got my first aid and my flagger certificate. So it's a great program.
Great. Well, my understanding is they need all sorts of over-the-road truckers. So
yeah. Oh, yeah.
Hopefully that turns into some.
It's the B's. It's not the big. I'm going to get into it, and then hopefully, maybe by the end of the year I'll get my A's. But right now they're just paying for the B's. Everything's free.
Yeah.
And you can't beat that. Like, you just can't beat. I mean, it's a great program. So,
well, one thing to keep in mind, and this has to do with your Carroll County probation, you can't leave Georgia without permission. So if you get a job like, woohoo, I'm driving from Georgia to Wyoming and back all the time, moving freight.
Right. Make sure they know.
Yeah, that's something that you need to coordinate with probation in advance rather than saying, oh, by the way, I just went to Wyoming. Now, there are plenty of people who do local trucking and you just have to stay in Georgia. It's still a long drive to Albany, and stuff needs to get from A to B. And that's not this case. So I'm just throwing you a little word of advice that you're going to want to coordinate with your probation officer.
I never even thought about that. So yeah, thank you. You need to discuss that.
Okay.
Yeah.
All right. Well, I similarly find it's a factual basis for your plea. I think the case was a little more complicated for you because it sounds like you were driving and the default is what's in a car belongs to the driver. Right. I also find that your plea is knowing and voluntary, meaning you've understood what we discussed and that no one's forced you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Merka, I am going to sentence you similarly given the age of this case, meaning that whatever happened on December 29th, 2021 was so long ago. I'm going to sentence you to 6 months probation on count 3. The other counts are being dismissed by the state. You will forfeit any property that was seized, so don't go down and try to get it. And it will be a condition of your probation that you continue to participate in the rehabilitation work that you've already started through Carroll County and everything you're doing. I'm not going to impose an additional requirement. It's just a parallel one that you need to continue to participate in that work. And I think that's it. Do you have any questions about that?
I do not. Thank you.
Ms. Nix, can someone in my office sign your name to the indictment?
Yes, sir.
Ms. Wood, can we sign for you?
Yes, Judge.
Mr. McGillicuddy, is it okay if someone in my office signs your name indicating your misdemeanor plea?
Yes, sir.
And Ms. Merka, can we sign your name to the indictment?
Absolutely.
Ms. Brown, can we sign for you?
Yes, Your Honor.
Great. Officer Evans, you don't need to give any reporting instructions to Ms. Merka. She's on misdemeanor probation and already active with Carroll County. Mr. McGillicuddy is switching from unsupervised to supervised. Do you need to give him any reporting instructions?
Yes, Your Honor. Mr. McGillicuddy, are you still at 1284?
Yes, ma'am.
Okay, you're going to contact Officer Relaford at 404-558-1047 within 48 hours, just to let him know what's going on, okay?
Yes, ma'am.
Will Officer Relaford know what's going on, that we're back to active probation?
Oh, he will know.
Okay.
Yes, he'll know once I get his profile set up today in the portal.
Okay.
Officer
Fantastic.
Evans,
No problem. Thank you.
was it 404-558-1047?
404-558-1047. Yes, ma'am.
Thank you.
No problem.
All right. That's it. Thank you, Ms. Brown, for dialing in. Ms. Merka, good luck with.
Thank you.
Oh, yes, Ms. Brown.
How does Ms. Merker report to misdemeanor probation?
Great question. Ms. Nelson will be sending to you, Ms. Brown, the basic information about our misdemeanor probation. And it may be that they are perfectly okay. Do you live in Carroll County, Ms. Merka?
No, sir. I actually report to Rockdale County.
Okay. So
That's
you
where I
don't
go
live in
3 days
Fulton.
a week.
Got it. Your lawyer will get the information about misdemeanor probation. She will pass it on to you, and it will either be your obligation to call them or they'll call you. But I'll tell you, if it's been a week and there's been no connection, you should reach out to Ms. Brown to say, hey, I don't want to get a warrant. What's going on? But Ms. Nelson, who works with me, will get to Ms. Brown the basics on how to establish that initial contact with misdemeanor probation.
Okay. And I'm not going to get like this. I just don't want, I heard, the prosecutor earlier say that that my probation could be revoked because of this guilty plea.
You were on probation. You were not on probation when this happened, so you're fine.
Okay. I just don't want to be, sitting in class and them come get me and
No. The timeline doesn't work that way. This happened in December of 21 and you were not on probation out of Carroll County for that. So that's not an issue.
Okay.
All right.
Thank you.
You bet. Thank you. Thank you, Ms. Brown.
Thank you.
Thank you, Miss Brown.
Thank you, Judge.
I will be talking to you soon. Okay.
Thank you, Ms. Wood.
Thank you.
Have a
All
nice
right.
day.
All right. So Ms. Willingham reached out saying she's got a timing issue. Ms. Willingham, you still there?
I am, Judge, and I now have until about 10:30. But I definitely would like to try and do Mr. Ross. If I just need to forward the Zoom link to the victim.
He's up next on the calendar, so that's what we're doing.
And I'm about to forward her the link. Apparently, she was just in a car accident. She was on her way here, but she wants to be on. So if you just give me 1 second, I'm going to switch screens, email her, and then we can do Mr. Ross.
I think we can. Where's Mr. Ross?
In custody.
He's in custody. Okay, then we can do that. Uh-oh.
Oh, no. So he's not actually.
Oh, hold on, Ms. Willingham.
So that's what I thought. That's what I thought might happen.
He's in Cal.
He's in Coweta County, so we cannot do that today.
Okay.
Darn it.
And I will notify, I will notify the victim. I know that that is actually, I did reach out, but it was kind of late last week. The victim actually contacted me and thought that he was in Coweta and was trying to make sure. Well, now she's texting saying he's in Atlanta. Either way, Judge, I will notify her that we will have to reset this.
Right, we'll figure out where he is and we'll get him here. It sounds like Ms. Wood, it's ready for a plea whenever we can get everyone in the right place. Okay, that's our project to figure out where he is, and maybe he's done with the loan out, but he was not brought over today because he didn't show in the system as being available for transportation. So that's on hold. The next one up is Mr. Gibson. Are you able to do that now, or do we hold on? Ms. Rios?
No,
We're ready on Mr. Gibson.
Okay. Does that work for you, Ms. Willingham, or do you want to do that later?
no, I can do Mr. Gibson.
All right, let's do that.
Did you talk to him?
I don't know. I don't think he's here.
Yeah, he's not here yet.
What are you doing today?
He's at ACDC. They haven't brought him yet.
All right, we don't have Mr. Gibson yet. He will be here. No one wanted to tell me that. Let me see, Ms. Willingham, if we got anything else. We could do the Charles inquiry.
Judge, if he's here, I need just 5 minutes with him. I have an offer that I think he'll want to take.
Okay.
And
Is
I will
Charles-
just stand by.
Is Charles here?
Yeah.
Okay. If Ms. Wood could talk to Charles, can we do a plea while you do that?
Yes.
Okay. Ms. Madden, are you ready with Mr. Dabney? Okay, so we're gonna do that electronically if that's okay.
That's fine.
Okay, then let's do that. Come on up, Mr. Dabney.
Can you approach with him?
Sure, thank you.
Everything.
I'm well, yourself?
Yeah, it's Amina Dickerson. She actually was here. She just left. I'm gonna text her.
Okay.
Mhm.
The system.
You guys should switch sides.
Oh.
Just the court reporter can hear you better if you're closer to the microphone. All right, Ms. Nix, are you ready?
Yes, one.
Just make sure you speak in the microphone. Yes, no, yes, Your Honor.
Okay. Yes, sir.
All right. This is 23 SC 190-872, State versus Chad Dabney. Mr. Dabney is in court with his lawyer, and we have Ms. Nix as the prosecutor. Mr. Dabney, in a moment, Ms. Nix is going to put you under oath. Once you're under oath, make sure you answer all her questions truthfully and completely. And also make sure that if at any point you've got a question about anything, let your lawyer or me know so we can work through that, okay?
Yes, sir.
All right, Ms. Nix.
Thank you, Judge. Mr. Dabney, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give of the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Chad Dewey Dabney.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
39.
How far have you gone in school?
GED.
Is English your native or dominant language?
Yes. Yes, ma'am.
Do you understand that you've been charged with the following offenses? Trafficking in illegal drugs, possession of a firearm during the commission of a felony, possession of drug-related objects, willful obstruction of law enforcement officers, and use of a firearm by convicted felon during the commission of a crime.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Madden?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Madden, do you waive a formal reading of the indictment for purposes of the plea?
Yes, we've gone over the charging document, so waive.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Dabney, do you remember having been arrested on these charges?
Ma'am.
Do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court?
Yes, ma'am.
As to count one, the state will reduce to possession with intent to distribute and recommend a sentence of 10 years to serve 412 days, which is the time you've already served, and the balance probated. Count two, state recommends a 5-year sentence probated consecutive to count one, and state will null pros counts 3 through 5 upon a plea to counts 1 and 2. Conditions are no contact with co-defendant Quincy Beavers. Stay away from the incident location, which is 1295 Donnelly Avenue Southwest. Submit to random drug screens. Complete 300 hours of community service. Testify truthfully if called as a witness against Quincy Beavers. Forfeit all seized property. Possess no weapons or any weapon replicas. And maintain full-time employment or full-time school. Do you understand that's the state's recommended sentence?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, I'm sorry, I skipped something. Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today, you do not have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
Only here.
You're on probation now in Fulton?
He's on
Yeah.
probation in Fulton County. Yes, Judge.
Okay.
Do you understand that your probation or parole may be revoked based on your entering a guilty plea today?
Is this the case that your probation was already revoked as a part of going to resolve everything today?
So,
Judge, initially when he was arrested on this charge, his probation was revoked as a result of this case. That's where the time that he's already served. So my hope is that we were going to resolve everything today.
What's the other case number?
It is 19 SC 170057.
All right, I'll take a look at that. Mr. Dabney, if you had your probation revoked in that 19 SC case already because of the facts of this case, and it may have been just because of the arrest, you're not going to be re-revoked because you're now pleading guilty to the same set of facts. I'm going to check the docket, but one, I wouldn't do the revocation. Well, we can talk about it, but let me take a look at the docket.
Yes, sir.
It sounds like it's already been addressed, and your lawyer would know that, but I'm going to look while you all keep talking.
yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Judge, we're
No.
going to be entering this pursuant to Alfred v. North Carolina. I can explain further as to his version of the facts, but he's pleading guilty because he does believe it's in his best interest and that he could be found guilty if he were to go to trial.
Okay.
Right. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, ma'am.
How do you plead to the charges of possession with intent to distribute cocaine and possession of a firearm during the commission of a felony in indictment number 23 SC 190872?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? And since these are felonies, you have only 4 years from today to do so.
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about September 8th of 2022, officers executed a search warrant at 1295 Donnelly Avenue Southwest, apartment B9. Mr. Dabney was in the house and was observed coming out. He saw the officers and immediately went back inside. Officers conducted the search warrant, found numerous found a bunch of drugs, including cocaine, in an amount that was with the intent to distribute. The defendant was found in a bathroom, I'm sorry, in a closet that was next to a bathroom in which it appeared that someone had been trying to flush some of the drugs that were found in this apartment. And while Mr. Dabney was not the original target of this search warrant, the state believes that the facts would show that he was participating in the selling of drugs from this apartment, as evidenced by his attempt to flush the drugs. The co-defendant, Mr. Beavers, his case is still in judicial hold. He is not, we don't have a hold on him. And Mr. Beavers was found in the living room. There was a Smith and Wesson handgun found in the apartment, and the defendant has 3 prior felonies, all drug cases in Fulton County. Nothing further from the state.
All right. Thank you. Ms. Tyson, do you have criminal history information on Mr. Dabney?
Yes, Your Honor. We have 9 arrest cycles beginning in 2005. 1 felony conviction outside the 10-year period out of Fulton County for purchase, possession, control of drugs. That's from 2005. Let's see. More recent felony conviction out of Fulton County for receipt, possession, or transport of found by convicted felon or felony first offender. Possession of a firearm or knife during the commission of. Purchase, possession, or have control of substance in Schedule 1 or narcotic in Schedule 2. Purchase, possession, manufacture, distribution, or sale of marijuana, and possession of cocaine with intent to distribute. That's from July of 2020. And he was sentenced to a suspended sentence of 5 years and Looks like probation for 8 years and 6 months on that case. And he has another felony conviction out of for aggravated assault and receipt, possession, or transport of found by convicted felon, a felony first offender. That's also from July of 2020. His previous arrest to this case was July 19th, 2019. And that was, let's see, that was the most recent felony conviction, Your Honor.
Okay, thank you.
You're welcome.
All right, so Mr. Dabney, I'm going to hear from your lawyer and you in just a minute, but to clear up this 19 SC situation, that's a case in front of Judge Ingram, and you were revoked for a year by her because of your arrest in this case. So you cannot be further revoked because you're now pleading guilty to it. There's already been a probation consequence for you, basically a sentence that you've served in connection with this set of facts.
Yes, sir.
So what your lawyer told you was right. Ms. Madden, what do you want to tell me about Mr. Dabney and why someone who seems to have been in this line of work for a while should get this kind of sentence?
Yes, Judge. My client is 39 years old. He's a lifelong resident of Georgia. With respect to the facts of this case, it was a search warrant case. There were 2 individuals that were named in the search warrant. Neither of those persons were my client. There were also a description that was given. It was about, I guess, a month-long investigation that police had done where they were watching the house. None of the descriptions that were given matched my client. Obviously, with his criminal history, he had no ties to the house. I mean, there was no mail that was there. The address on his driver's license, there was nothing really to tie him to the house other than his mere presence. Nothing was found on his person, but obviously his behavior when the police came. And his criminal history, I've explained to him if we were to take the case to trial, his defense obviously would be mere presence, but a jury could still find him guilty, and then he would have to possibly, if he were to testify, explain what he was doing in the house. We believe he was there to smoke and purchase weed. I've talked to him about if he had any drug addictions. He said it was just marijuana. He doesn't feel that he has a drug problem, but I told him obviously on probation, he'll be subject to random drug and alcohol screens, but he knows that he cannot be in places like this. He cannot go to homes to purchase drugs, even if he was not there to sell drugs. So that was essentially his defense. Since he was released, again, his probation was revoked for a year as a result of this. He was incarcerated after that, I think a little over a month, but because the case had not been indicted, he was entitled to a bond. He was on an ankle monitor. I believe Your Honor is the one who actually took him off the ankle monitor, but he had otherwise been compliant. He has been working. He said it's been difficult for him to find traditional work because of the open case and his felony convictions, but he's actually a very talented chef. I've even tasted his food. He is in the process of saving for a food truck, but he does sell plates. He's always sending me pictures of his food. And so that's what he's been doing since he's been out. Again, he's a little bit older. He does have children. Again, he has ties to the community. I believe that he does not want to continue to be in and out of the system. So I'm hoping that this will be the last time that the court has to see him. It's a very long probated sentence, obviously. So if he were to mess up, he has a lot hanging over his head, a lot of exposure. But this has been something that the state and I've negotiated for quite some time. I think it's a very fair resolution. Initially, obviously, trafficking carries mandatory minimum time, and he was aware of that. So we feel like this is something that he should avail himself of. So we're just asking the court to accept the recommendation.
Okay, thank you. Mr. Dabney, how many kids do you have?
One.
One. How old is your kid?
11.
A boy or a girl?
Girl.
Does she live with you?
Not right now.
How often do you see her?
I see her all the time.
Does that mean once a month or every day or?
Every other day.
She stay with her mom?
Yes.
Locally?
Yes.
You spent over a month in jail last year. I'm trying to figure out if that was related to this case.
Oh, I'm sorry, didn't mean to
No, either one of you can answer. You were arrested about this time last year and were in for over a month. Is that a different set of charges?
It was supposedly the same set of charges. He actually was transferred into the prison system once he had the probation revocation, and then he was booked back into the Fulton County Jail. His case had not.
So that would be the new booking number. There's the old booking number that says 99 days and then moved to Department of Corrections. And that was released to Department of Corrections in December of 2022. That makes sense. Then he was back in September. So that would have been the year revocation. And then you sat for another month until, I guess, either we reinstated a bond or he got a bond.
He had a bond because he was in excess for, I think it was more than 90 days, but the bond was too high. So I had to go back for a bond reduction. And that's when he was placed on the ankle monitor. But all of the time that he served under the two booking numbers were related to this case.
Okay, that's what I wanted to understand. Okay. Mr. Dabney, do you have any questions about anything we discussed?
No, sir.
Anything you want to add?
No, sir.
You understand your lawyer's very, very good advice to not go into trap houses like that, because it's just, you're past that. You got a kid, you want to have a career, and the world is going to view you as an operator of the place because of your past and not just a customer. And so you got to roll in a different way.
Yes, sir.
Okay. You look confused by that. What part? Okay, you got it?
Yes.
Okay, it's just, those days are gone. That's just not something you should risk. Won't be good for your family. Most of all, it won't be good for you. If we're talking again and you got arrested in a place like that, I have a lot of probation to work with. And I don't say that in any way to be threatening. I wish you the best. And I want to see your food truck and I want to try your food truck. But you just need to handle things a little bit differently than what happened. And, it was 2 years ago, almost to the day, 2 years ago and 2 days. It's been a long 2 years.
Yes, sir.
Okay. All right. Mr. Dabney, you initialed a whole bunch of things on this form called Plea of Guilty. Is this your signature on the 4th page of the document?
Yes, sir.
And Ms. Madden, you discussed this with your client and you signed on page 5?
I did, Your Honor.
All right, I'll make this part of the record. Mr. Dabney, I find there's a factual basis for your plea. You were clearly in the wrong place at the wrong time. And I agree with your lawyer's assessment that there is a defense, but it's a iffy defense, given the fact that if you were to claim, I didn't know what was going on, the state would probably be able to get in all your other convictions in an effort to show knowledge and intent. And then the jury would be looking at you in a way you don't want them to be looking at you, as like, hey, this guy's a veteran of the business. Of course he was there as part of the business, as opposed to maybe just a customer. I also find that your plea is knowing and voluntary. That means you've understood what we talked about and no one has forced you to move forward in this way. Do you agree with that?
Yes, sir.
You're entering your plea under the U.S. Supreme Court case of North Carolina versus Alford. That is simply a way for a defendant to say, I didn't do all the things the state said, or it didn't go down quite the way they said, but given these negotiations, I would like to move forward in the way that my lawyer has described. Is that a fair assessment of where you are?
Yes, sir.
Okay, I'll accept your plea. I'm going to sentence you on count 1 to 10 years to serve 1 month. I'm sorry, to serve 1 year and 1 month. Count 2 is 5 years. It has to run consecutive. So it's a total of 15 years to serve 1 year and 1 month. That will be followed by 5 years of probation, and the remainder is suspended. So there'll be 5 years when probation's looking over your shoulder, and then the rest is suspended. But hear me out on all this. It is a special condition of your suspended sentence that you obey the laws of Georgia and the United States. And I add that because if we're together again in a couple of years, you're still on probation, but we're together again because you were in a different place and there was a bunch of drugs and there was a gun, I can revoke that suspended sentence as well, because a special condition of it is that you obey the law. That'll be the only condition of it. When the part is suspended, you don't have to report to probation or anything like that. But it's out there just as a little lever to have to encourage you to make different decisions now that you're almost 40 years old. Okay?
Yes, sir.
It will be a special condition of the probated part, the 5 years of your probation. Number 1, that you have no contact with your co-defendant, Mr. Beavers. Was he named in the search warrant?
He was not, from my recollection.
I believe he was.
Okay, I mean, it doesn't matter. I'm just curious if there was no one they were looking for in the house.
I know there were I don't remember that name, but I could be mistaken.
Okay. You'll need to stay away from Donnelly Avenue. You'll need to complete 300 hours. That's a lot of hours, but I think it makes sense of community service. And know this about community service. It doesn't have to be you walking along Bolton Road picking up trash. If you find a way to give back to the community that's meaningful to you, and I'm making this up, but working at a rec center where you coach a team or something, probation will probably roll with that. You need to have written certification. Hey, I worked 8 hours today or 4 hours today doing X or Y. But I encourage you to be proactive. If you find something that is volunteer work that means something to you, bank the hours that way. If you don't, if you just say, hey, I need some hours, probation will say, great, there's a park where we're picking up trash. And there's nothing wrong with that either. That's good for the park. That just may be something you're less excited about. So you've got a lot of hours to work with. You will be required to testify truthfully if there is ever a trial of your co-defendant, and you forfeit anything and everything that was seized from that house. I'm going to have you submit to a drug and alcohol abuse evaluation. If that professional determines that there's something you're using and you can't quite control it and you need some treatment, then that treatment will be part of your probation. I think I covered everything that I intended to. Ms. Nix, anything else?
No, sir.
Ms. Madden, any concerns about that?
No, Your Honor, I think you covered everything. Just that he would be getting credit for the time that he's already served.
You will. I'm going to let Ms. Nelson do that math, but that 1 year and 1 month you've already served. That was part of this case. Ms. Nix, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Madden, can we sign for you?
Yes, of course.
And Mr. Dabney, is it okay if we sign your name to the indictment indicating your offered plea to counts 1 reduced and count 2?
Yes, sir.
All right. I think that's it. Now, are you reporting to probation now on your other case, this 19 SC case?
No, sir.
All right, then Officer Evans is going to give you reporting instructions because you are going to be reporting again for probation.
Thank you, Your Honor. Mr. Dabney, can you please verify your address?
1456 Copeland Avenue, Southwest Atlanta.
Okay, you're going to report to the Atlanta Probation Office on September 27, 2024 at 8:30 a.m. And may I have a good contact number for you?
770-256-6610.
Thank you, Mr.
And
Dabney.
404
Okay.
396-1562.
Are those both your numbers or is one of them a contact?
One of them a contact.
Who's your contact?
My mother.
Your mother? Which one is your mother?
The 770 number.
Okay, and that's Miss Vicky Dabney?
Yes, ma'am.
Okay. So failure to report on September 27, 24 at 8:30 to the Atlanta Probation Office may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
You know what?
Good luck to you. Thank you.
Mhm.
Okay.
All right. Thank you both.
Thank you, Judge. Good seeing you.
Same. Ms. Willingham, do we have enough time to do the Gibson matter, or do you need
Judge,
to?
I think we do, because I'll just have to I'm in my office. I'll just have to walk around the corner to E.D. Young's office. So I think we should be good.
Okay.
This is a pretty straightforward plea.
So they say. Okay. So can we bring, did I get the name right? It is Gibson that we're doing?
Oh, I'm sorry.
Oh, no, Hamilton. Oh, I thought we were doing.
No, we're doing Mr. Charles. I'm sorry. Gibson wasn't here yet. That's the guy from, he's here now, but that's okay. We'll do him later. We're doing, is it Mr. Hamilton or Mr. Charles?
It's Mr. Charles.
Mr. Charles. Let's bring out Mr. Charles, please.
And Judge, I did email the terms for Gibson to Ms. Nix. So if you all want to proceed on that after I leave without me, that's fine, because she has everything she should need for that.
Great, thank you. Oh, this is an old case.
The next week. He should be downstairs.
Okay, just be sure to speak loudly and clearly into the mic when you're answering questions, okay?
Yes, ma'am.
Hello, Mr. Charles.
Hey, how you doing?
I'm all right. You're gonna need to speak up a little bit.
I'm sorry. How you doing?
That's okay. It's not for me. It's for the court reporter. I could hear you, but our court reporter is virtual today. Mr. Charles, you are charged in 19 SC 173633 with robbery and a few other offenses. Ms. Willingham, who you can see on the screen there, she's wearing the orange jacket because it's fall. She is going to be handling your plea for the state. She's the prosecutor. She's going to put you under oath in just a moment. And if you have any questions at any time during our conversation, please let Ms. Wood or me know so we can work through those. All right?
Yes, sir.
All right, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Ma'am.
You can put your hand down. Please state your name and your age.
Hamilton Charles, 36 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
I can hear him without him leaning in.
Okay, you don't need to lean in. That was the court reporter you just heard. No, you're it's all good.
Hopefully the last.
Okay, well, that's on you.
How far did you go in school?
The 11th.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count one of this indictment, robbery, will be reduced to disorderly conduct, and all remaining charges in this indictment will be null pros. You would be required to complete 12 months probation, sorry, I'm trying to get to the email, the terms, and complete 60 hours of community service, and your probation can terminate upon completion of the community service, and no violent contact with the victim in this case. Is that what was explained to you?
Yes, ma'am.
How many hours of community service? 60, did you say?
Yes.
Okay, and count one is being reduced and the rest are being null prost?
Yes, Your Honor.
Got it, thank you.
Disorderly conduct has a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 12 months probation that can terminate upon completion of 60 hours of community service. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as discussed, you'd be required to complete 60 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Make sure that you understand and it's your decision to plead guilty.
Oh, yes. Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Your Honor, should the state proceed forward with this case, the state would prove beyond a reasonable doubt that on November 29th of 2019 at 1400 Bolton Road, Northwest Atlanta, Georgia, in Fulton County, officers responded, and upon arrival, they met with an adult victim, Cassandra Billingsley, whom stated that her live-in boyfriend, Hamilton Charles, entered the home in a loud, angry manner. Ms. Billingsley stated that when asked her daughter, Nakia, that she asked her daughter, Nakia, to call the police. Hamilton Charles tackled the 9-year-old to the ground. Nakia Wilkins was holding her 11-month-old sister, Lyrical, at the time she was tackled. Hamilton Charles had warrants at that time out of Cobb County and did not want the police involved. Your Honor, I've had an opportunity to speak with Ms. Billingsley, and in my communications with her yesterday, she stated that this isn't really how it happened, that Nakia actually, she was trying to get her phone from Mr. Charles, and Nakia kind of intervened and got in between them, and at that time, Nakia fell. She stated that the family is back together. They have been functioning perfectly fine since this incident happened in 2019, that Nakia and Mr. Charles actually have a great relationship, and she's just ready for this to be resolved, and that is all from the state.
So Lyrical was not injured when this happened, as best you know? I appreciate this was 4-5 years ago.
No, in speaking with Ms. Billingsley, no one was actually injured. She wasn't quite sure why it was charged with anything in related to harming the children. She said she was actually very confused by that. So, especially since she said the altercation was really between her and Mr. Charles. I did explain to her how the children were impacted, but she wasn't quite sure why they were involved because neither of them were injured.
Okay, well, and it doesn't allege injury. I understand the allegation. It's physical contact. So if Mr. Charles, when he was being disorderly, elbowed or shoved or even bumped into Ms. Wilkins, there's your simple battery. It's a pretty elastic misdemeanor.
Correct.
But more importantly, Ms. Billingsley is telling you that her recollection of something that happened almost 5 years ago is a little different from what it sounds like on paper.
Yes.
Okay. All right. Thank you so much. Ms. Tyson, do you have criminal history information on Mr. Charles?
Yes, Your Honor. I have 11 arrest cycles beginning in 2005. We have a felony case out of DeKalb County from, 2007, carrying weapons within school safety zones. He received first offender treatment on that case, and it looks like he successfully completed his conditions in 2017, and the case was sealed. Let's see. within the last 10 years. Looks like no felony convictions within the last 10 years. He does have 5 violations of probation and 1 FTA from 2012. Let's see. Last arrest was April 11th of 2018 before this case, and that was for one of those violations of probation. And he had 1 cycle out of Tennessee, and that's from 2015, and it was for shoplifting. And it looks like that case was dismissed in 2015 as well. Nothing to add.
All right, thank you so much. Ms. Wood.
Thank you, Judge. Mr. Charles is 36 years old. He is a resident of the Atlanta area. He has 4 children. He is gainfully employed at UPS. This was all just a big misunderstanding 5 years ago, and he does dispute the tackling, but he understands that this is a wonderful resolution for this incident, Judge, and so he does ask that you accept the state's recommendation. He has been in custody, I think, about a week, and I do want to thank Ms. Nelson for putting this on our radar.
Yes, this moves so quickly. Go, Ms. Nelson.
And also for Ms. Willingham for being so willing to work with us. So otherwise, we just ask that you accept the state's recommendation.
Good team effort. Mr. Charles, who's here in court with you?
My mom.
Okay. Are you and Ms. Billingsley still connected?
Yes, sir.
Do you all live together, or you just sometimes spend time together?
We spend time together at my mom's house, family barbecues or things like that. We have no conflict relationship.
Are any of her kids your kids?
Yes, Lyrical, and I share a stepchild, which is Nakia, with her.
Okay. So when Ms. Wood said you've got 4 kids, those are 2 of the 4?
No, I have 4 biological, and the stepchild, I guess, will make 5.
Okay.
But,
one of your biologicals is Lyrical.
yes, sir.
Got it. And then you've got 3 others. Are they with the same mother, or I don't mean Ms. Billingsley, but are the 3 of them, did they share the same mom, or
no, different parents?
Okay. Are they all in the Atlanta area?
Yes. Well, one is in Texas.
Okay.
My son.
How old is he?
13.
13. Is that the oldest?
Yes.
Okay. All right. And what do you do at UPS?
Drive trucks.
What does that mean? Like the brown ones that drop something off, or the big 18?
A shifter in the yard, move around the trailers.
Okay.
Out the yard.
The big yard on Fulton Industrial?
Yes, sir.
All right. How long have you been doing that?
8 years.
Will you still have your job when you get out?
Yes, sir.
Why do you think that?
Talk to my supervisor.
Okay.
Try to keep it.
Good. I didn't say, why do you think that? Because I'm going to change it, but you have an assurance that that job is still there.
Yes, sir.
Good. Okay. Anything you have questions about, or anything you want to add?
No, sir.
All right. But you and Ms. Billingsley, it's a good situation now.
Yes.
All right. Do you agree with that, Mom?
Absolutely.
Okay. All right. Mr. Charles, I find there's a factual basis for your plea to disorderly conduct almost 5 years ago. And your plea is knowing and voluntary. I will accept it. I'm going to sentence you to 10 months of probation. You'll need to complete 60 hours of community service and no violent contact with Ms. Billingsley while you're on probation. I will allow the probation to be terminated after 6 months if you've completed all of the community service. Okay.
Yes, sir.
Ms. Wood is going to get you the reporting instructions for misdemeanor probation. Their office is like a block from here. They may not make you come to the office. It may be that you can just do it over the phone. Do what they tell you. Because if you don't, then they're going to send me a warrant and everything gets turned upside down again. And your supervisor may get tired of giving you second chances at work. Okay.
Yes, sir.
All right. Good luck with everything.
Thanks.
Ms. Wood, we got one other thing to cover, but yes, you.
The signature provision is, I was just.
That's what I was going to say. All right. Ms. Willingham, can we sign this indictment for you?
Yes, Your Honor.
All right. Ms. Wood?
Yes, Judge.
And Mr. Charles, is it okay if we electronically sign your name to the indictment?
Yes, sir.
All right. Done. Thank you, Ms. Willingham.
Thank you, Judge. And I'll check back in to make sure if you guys need me to come back, I will.
Okay. Will do. Bye-bye. All right. We will take a quick break. I promise it'll be quick. When we get back, what are we doing?
Will you do Mr. Glass?
Okay.
Mr. Gibson is not up yet, but then.
Well, during the break, they can bring them up. And then is Ms. Hayes in custody?
Yes, so.
That's off the trial calendar coming up.
Yeah,
Way to
well,
get-
it's not gonna be a trial.
I thought it was gonna be a plea. It's not gonna be a plea?
Oh, it is gonna be a plea. We just need you to proffer, and then I'm not sure if we can do today.
Oh, she was brought over for the proffer?
And, well, I initially proffered, I thought we could do the plea, but Ms. Nix.
Yeah, it says plea, not proffer on my calendar.
I was hoping we could do both.
Okay. I'm around all afternoon too, so if we can get Ms. Nix back, we can leave this running. I have a 12:30 hard stop for a case management meeting, and then I'm available again. So, but why don't we'll take a quick break. I'll come back out as soon as Deputy Gordon gets me. He'll get me once Gibson is up. So we can certainly do Gibson and Glass. And then tell me, Ms. Nix, how is the Hayes situation going to be structured? Are you chatting with Ms. Hayes or law enforcement, or what's happening?
My investigator and I will be, I believe my supervisor is also coming. And so I don't know the logistics of it. If we do it in here or if we need
You're welcome to
to
do,
go
well,
back or.
you can do it in here. I guess if you're, I'll talk to Deputy Gordon about it. I don't want to tie him up for 2 hours if that, you take as long as you need to talk to the person. But if it's in here, maybe he can lock the place because there's an investigator here, but I'll talk with him. This is sort of the easiest, given that she'll be coming through that door. It's a little easier than everyone going back there and sitting on those little folding chairs. So, is Glass up? She's not. I'm sorry, Hayes, is Hayes up? Is she here? So she maybe, okay, so she and Gibson need to be brought up. And then we'll at least take those two pleas and hash out the details of the Hayes conversation. All right. I think that's all that's left on the calendar. Is that right? It's basically the Rios segment of the calendar.
Yes.
All right. Sounds good. So Mr. Wright's family came here yesterday, but then I sent them down to 1D.
Thank you,
I
Judge.
said, oh yeah, we heard it's a new judge. I said, it's actually an old judge. But yes, be down there.
Yes, I had forgotten to tell them it would not be here.
That's all right. They were very pleasant. And like I said, we'll see how the list for next week evolves, but the mystery to me is this Adams case out of Judge Schwal's courtroom.
I was just looking in Odyssey. I was also trying to figure out what was happening.
And there's no one on the I mean, you have to work through the DA's office, I guess, because it's not a PD case.
Right. And I guess Ms. Fagan picked the jury yesterday.
Mm-hmm. Yep, and apparently only been on the case for like a week and a half.
Saw that.
Woo, talk about parachuting in.
Yes, I did see that.
So is Ms. Rios talking with Mr. Glass now? Or, okay. I thought he was already up.
It's Gibbs.
She's talking to Gibson.
Yeah.
Okay. We can do either one of them. And is Ms. Nix back there? Okay. Okay.
Judge, I'm gonna step out and call the victim in position number 3, Mr. Ross. She's texting me saying he's definitely not in Coweta anymore. So Ms. Nelson and I talked about that one can be a Zoom plea because it's a probation outcome.
Okay.
So if we can track him down.
Yeah, let's see. The booking screen says he's loaned out to Coweta. So I don't, apparently the alleged victim in his case is saying he's not there anymore. Hope they didn't let him go.
I never actually seen a loan out to a different. I seen a loan out usually to Grady. So this was.
Yeah, I don't know how that plays out. Hi there. Were you here to talk about Mr. Ross and the loan out?
Yes.
Yeah, what do you know?
They are confirming where he's at because I told them, I was told that they think he's back in Fulton. So they're gonna call transport to make sure that they haven't updated the booking screen. And if so.
They have not. I'm looking at the booking screen.
Well, no, like, do they need to update?
Oh, got it. Got it.
And then the second question is if we can get them on a Zoom call in Coweta County, do you want him?
Ms. Wood just said Zoom would work.
Okay.
Wherever we get them on a screen.
Okay.
So if we can do it, that's great. It would probably need to be in the afternoon. But you could zoom in for that too, or come back in here. Is it?
Mr. Ross is Miss Willingham.
It's Miss Willingham, right? Okay.
Okay, so if Zoom would be this afternoon, like 2%.
Yeah.
Okay.
So Ms. Nelson is trying to track Mr. Ross down. If he is in Coweta, she's going to see if she can get him on Zoom in Coweta. Probably would do it around 2:00. But she's got the transport folks checking too.
Thank you, Judge.
The booking screen says he's not here, but that doesn't mean he's not here. It's just what it says. It's in red though. Hey, Ms. Rios, you ready?
Yes.
What would you like to do first?
Do Mr. Glass first.
Mhm. It's so silly that that's all it takes is for to make it a signature.
I like it. Easy, not important. Physically. And my handwriting is like this.
Ms. Rivers, are you good to go?
Yes, I'm ready.
Great. Okay, this is position 5. It's 24 SC 001586, State versus William Glass. Hello, Mr. Glass.
Hey, how you doing today, Mr. McBurney?
I'm all right. How are you doing today?
I'm blessed to be alive.
Good. I'm glad you're alive. Mr. Glass, Ms. Rios tells me you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
In a moment, Ms. Nix, who's seated behind you, but you can see her on the screen, will put you under oath, ask you a whole bunch of questions. Make sure you answer truthfully. And please let me know if you've got any questions of your own, okay?
Yes, sir.
All right, Ms. Nix.
Thank you, Judge. Mr. Glass, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
My name is William Glass.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
Yes, it is.
What is that medication?
It's my mental health medication.
Does that medication affect your ability to understand this proceeding?
No, it doesn't.
When did you last get to take that medicine?
I took it yesterday.
Okay, so it's not that you haven't had it the whole time you've been in jail. You just didn't get it today.
Yeah, they don't give it because it makes you drowsy and stuff like that. So they don't want me to be judged with the medication.
Got it. What do you take the medication for?
I take it for PTSD, manic depression, and bipolar schizophrenia.
So it's more than one medicine that you take?
Yes, it is. It's like 3 different medicines.
And when did you last take it? Sometime yesterday?
Yeah, yesterday.
Okay. Does the fact that you have not had any of that medicine today make it difficult for you to understand what we're saying to each other?
No, it doesn't. It doesn't.
Okay. Thank you.
How old are you?
I'm 46, ma'am.
How far have you gone in school?
I'm graduating.
High school?
Yes, ma'am.
Is English your native or dominant language?
English, yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault. Count 2, terroristic threats. Count 3, interference with government property. And count 4, theft by shoplifting.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am, I have.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am, I have.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am, I am. Highly.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Mr. Glass, do you remember having been arrested on these charges?
Have I ever been arrested?
In this case, do you remember when you were arrested in this case where you were having a little issue with an officer and you kicked the patrol car, et cetera?
Yeah.
Okay. That was just a question. Make sure you remember your arrest here.
Yes, I remember.
Okay.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to count 1, state recommends a 20-year sentence that you serve 2 years, reduced to the time you've already served upon your entry and completion of drug court. Your probation can be terminated after 10 years if no further issues on probation. Count 2, state recommends a 5-year sentence, serve 2 years, reduced to the time you've served upon entry and completion of the drug court program, and that will run concurrent with count 1. Count 3 is the same sentence, concurrent with count 1, and state will null pros count 4 upon your plea to counts 1 through 3. Special conditions are that you attend and complete drug court, stay away from the incident location, which is 1217 Metropolitan Parkway, and have no contact with John Williams or Officer Jayana, Jayana Jefferson-Smalls, unless it is through her official law enforcement duties, and that you have a mental health evaluation and complete any treatment that is recommended.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you are pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, the court also has the right to run those sentences? I'm sorry.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
I was.
Are you today on probation?
Yes, I am. Yes.
Okay. Do you understand that your probation or parole?
Hold on one sec. You're on probation now.
I already had it like revoked. I already had the years revoked for what I'm in here for.
Okay.
I already had it revoked 7 months, 14 months. Served 14 months, but they gave me time served on it.
Okay.
For being violating this probation.
Got it.
Do you understand that your probation or parole may be revoked based on your entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am, I understand.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated assault, terroristic threats, and interference with government property in indictment number 24 SC 001586?
Yes, I'm pleading Alfred.
Sorry, say that again.
I said, guilty by Alfred.
Oh, okay. Are you pleading guilty because you've decided it is in your best interest to do so?
Well, yes, I'll be honest, yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, I understand.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that since these are felonies, you only have 4 years from today to do so?
Okay.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about September 10th, 2023, the defendant was in the convenience store of a gas station at 1217 Metropolitan Parkway and shoplifted some beer cans. Officers responded initially to the shoplifting call. They also got a call for a fight. The defendant exited the convenience store and struck John Williams in the head with one of the beer cans. Then walked towards the Capitol View Apartments. Officer Jefferson Smalls found him at those apartments, brought him back to the convenience store where Mr. Williams ID'd him, and the clerk of the convenience store ID'd him as the assailant and shoplifter, respectively. The defendant was taken into custody and transported to jail. While he was in the back of Officer Jefferson Smalls' patrol vehicle, he kicked the windows, causing damage, and told Officer Jefferson Smalls that he would break the glass and kill her, and that occurred in Fulton County. The defendant has several prior felonies, counting 13, all in Fulton County. It started out, most of them were drugs, and he has escalated to more violent crimes. Most recent is a 2023 armed robbery conviction here in Fulton County. He was on.
It must be something other than an armed robbery conviction in 23, because that would be 10 years.
Yes, that's just what's on the GCIC.
Oh,
so
okay.
I didn't go back and check to see if it was reduced to a robbery.
Okay,
it was.
But the case he was on probation for and was revoked was a ag assault, also from a 2023 conviction, and the state has given this very generous offer. We've been having difficulty finding Mr. Williams, and the defendant was accepted into drug court based on a clear history of drug abuse. Sounds like there might be some co-occurring issues. We would prefer to get him to stop self-medicating with drugs and alcohol and get on a better path. So that is why the state has made this offer.
Okay. It looks like we lost probation and pretrial services. Hopefully probation will come back. Oh, Officer Evans is here. That's good. Okay. Officer Evans, is Mr. Glass on active probation in any other case? Officer Evans, you there?
3S185902. I'm showing a maximum release date of September 11th of 2026. And I would believe that will be when his probation would start on those two particular cases. He also has active probation on 22 SC 180179. And also out of Gwinnett County on 23 B004358 for family violence felony. And that 22 SC 180179 case is robbery by intimidation.
Okay. Your voice didn't come in till you were saying something about his probation may not start till he finishes the custodial part of his sentence. Is there some case where you think he's being shipped off to the Department of Corrections?
His 23 SC 185902 case, he was sentenced, and the 22 SC 185208 case, he was sentenced May 24th of 2023. And that sentence was 15 years to serve 5, balance of 10 years, probated, suspended upon entry into ITF aftercare portion of program. Ooh, hold on, let me pull up the actual disposition, Your Honor. But it appears that he may be serving some time. It looks like he might be part of the RSAT.
I'm not
Listening to this sentence. Must enter and successfully complete the ITF program and its aftercare to be assigned to a mental health officer, no contact with the victim, and stay away from the victim in their home, workplace. But he was sentenced to 15 years to serve 5, balance of 10 years probated.
Okay. In May of last year, and he's been in custody nonstop since. Well, but that was before this incident happened. After that, he must have gotten out. That wasn't a very effective 5-year sentence because this happened in September of 23.
I think they just didn't activate the case on my end. I apologize, Your Honor. But he is on active probation on those cases.
Okay. You got a terrible criminal history, Mr. Glass.
And that's where it stops at, right here. Right, trust me.
Yeah,
I'm done. The jail itself is. I'm done.
Well,
all this stuff I have to do, I don't think I'm gonna have no time to do nothing. Like,
do you have a place to stay when you get out?
Well, I was accepted at Georgia Works, so I can go there, and it's always the Salvation Army, but I got accepted at Georgia Works. So
okay.
I'm still gonna opt to go there, you know, like, cause
Well-
Does drug court provide housing? I think they help.
It does, and that's why I was asking, but we'll get there in a minute. Let me hear from you, Ms. Rios, about Mr. Glass and his situation.
Yes, Your Honor. Mr. Glass is 46 years old. He did graduate high school. He has several mental health diagnoses, manic depression, bipolar, schizophrenia. At the time of this incident, he has not been on medication for years, so he was self-medicating. Since he's been in jail, he has been on his medication. He said it has made a world of difference.
Yeah.
He wants some strictness. He said nothing has been working over the years. He's tired of the same situation. He has 15 children. He wants to be able to, at least try to be a dad to the ones that are still underage. Most of them are grown. He has some that are between the ages of 28 and 12. He has all girls. So he wants to,
You have 15 girls?
Yes.
What are the odds?
I know, right? I wanted a son. Yeah, I stopped.
Well, you should stop trying, okay? 15 is plenty.
Yes, I know.
You just didn't have a boy. It's all right.
Yeah, I know, right? So I'm just gonna have to let that go.
Maybe you don't have any Y's in there. Okay.
And so he wants a strict structure. We know how strict drug court is, and if he messes up, then we'll deal with it. But I think this will be his last chance. He has skill set. He has a forklift license. He has other certificates. He was in 2021 when he was doing okay for a little bit. He was working at Publix Distribution Center. He said he believes he would be able to go back, that they liked him when he was there. He did a good job. He did food prep, cooking. He also at the time was a warehouse supervisor for the shipping and purchases. So it's just the drugs that just make him a different person.
Yeah.
And he just wants to get a chance to try to be a good citizen and do what he's supposed to do now that he's medicated and not on drugs. I think he'll be able to do that.
Okay. And you believe, Ms. Rios, that Mr. Glass has been accepted in the drug court?
Yes, he has. We signed the paperwork and we already had the agreement, so I'll send it off now that.
Okay, so intake has met with Mr. Glass. It's not that you hope he gets in. They've said we'll take him.
Yes, he's been accepted.
Okay. Mr. Glass, anything you want to add?
I just like to thank the courts, for accepting, having mercy on me and stuff. I had a hard life, but there's no excuse to, to be in here that many times and stuff like that. So I'm gonna get out and apply myself and do what it is I'm supposed to do as a man to support my family. I'm gonna be a very effective member of society from now on out. I'm done with it.
Okay. Well, you talk the talk. We'll see what walk you walk. Tell me why this is an offered plea. Offered plea means I didn't do it, or it didn't really go down that way, or I don't remember because I was strung out. And so it may well be I hit a guy with a beer can.
I'm gonna be honest with you. I did everything except for hit the man.
Okay.
And he homeless, I'm homeless too. Like I ain't got nowhere to go. We can argue nothing about, but who gonna have the biggest tent or something like that. But honestly, I didn't.
Okay, so you took the beer, you fussed at the officer, all that kind of stuff. You're just saying.
I had public drunkenness too. I was drunk. I was told up.
That's what it sounds like.
Yeah, I had public drunk. I was drunk. I ain't gonna tell you no lie.
Okay, that just helps me understand the situation. What do you use when you aren't getting medication to help treat the symptoms? Is it alcohol? Is it cocaine? Is it marijuana? Is it street pills?
It's alcohol.
Alcohol is the main
worst enemy.
Okay. Does that lead to other things though? When you're drunk, then you smoke, or?
I smoke some marijuana, but hit a cigarette, it tastes horrible. It's the alcohol for me.
Okay. Yeah. Well, that's certainly something that drug court will address as well. Yeah. It sounds like you would be open to initially being in drug court housing. You can't do Georgia Works and drug court at the same time.
Okay.
They don't overlap. Drug court takes up most of your time for the first few months, and then we want you to be working. So Georgia Works and drug court, they do good things, but can't be in both programs at the same time because Georgia Works is going to want you in their classes and drug court's going to need you in their classes. So even though Georgia Works would provide you housing, they would do that if you're in the program. That's not how we're resolving this. So you either need to have your own place to stay, or at least for the first 3 months or so, drug court can provide supportive housing. I just need to know what to tell drug court.
Okay. Well, I opt for the supporting house.
Okay. All right. Well, I find there's a factual basis for your plea and that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which is just an acknowledgement that while you're on probation, if you have a minor violation, you and probation will resolve that. But if it's more significant, you get arrested again, or you get terminated from drug court. If they kick you out, that comes back to me and I will work through what the consequences are.
Okay.
Do you have any questions about anything we've discussed?
I was like wondering, like, I'm not in no rush, but I just want to know, like, what's how long did it take for them to get, you know?
So they do orientation every Tuesday. So you missed orientation today. Okay. Most likely it would be next Tuesday that they'll come get you. But they need to make sure that there is a bed in one of the places where they provide housing. So I'll reach out when we're done to say, it looks like Mr. Glass, assuming you've been accepted into drug court, is ready once housing is ready. It doesn't take that long. So if it's not next Tuesday, it'd be the Tuesday after that they come get you. You'll go to Hope Hall. That's where drug court occurs. And at the end of that session, you will be able to go to the housing. So you'll be out and about. Okay. You'll be wearing an ankle monitor for the first 30 days. Okay. Everyone who starts drug court, whether you're coming in through that door or that door, starts with an ankle monitor for the first 30 days. That's the toughest time. That's when people tend to say, yeah, I don't really want to do this. I'm going to go in this direction instead. Yeah. And we just find you sooner with the ankle monitor. Yeah. So that is how it will start. So next Tuesday or the Tuesday after. I think I already said this, but I find that your plea is knowing and voluntary. I do agree with Ms. Nix that this is a pretty darn lenient result for now. You've been in for over a year. So you've served a year for doing what you did. Yeah. And in the grand scheme of things, what you did, stealing some beer, fussing at an officer, isn't the worst thing. It's what you had been doing leading up to that. This is not your first case where you were engaging in dangerous activities, but it's just another sign that you need help. And that's what we're going to try to get you. You're 46. You're not getting younger. I have no idea what your health is, but it sounds like life has been difficult for you for a number of years. And I'm hopeful that you don't want to go back.
Oh, no, I don't.
And that ought to motivate you, because I'll tell you this, if we get 4 months into drug court and it blows up and you quit and you walk away from it, it's going to end in a pretty bad way, because there's going to be a lot of probation to work with. There are 2 drug court judges. I happen to be one of them. That's just a coincidence. So you've got a coin toss chance that I'll be the judge working with you in drug court. If you end up working with me, it's not because you took a plea here. They put one in front of Judge Krause, one with me, one with Krause, one with me. Okay. So it's just wherever we are on that little tracker, and it may be that you and I end up working together. Same program, just 2 different judges.
Okay.
All right. So on count 1, I'm going to sentence you to the 20 years to serve 2 years. Those 2 years, I need to figure out how to structure it, because you've done a year. I'm going to sentence you on count 2 to 1 year to serve. And count 3 is 1 year to serve. Those are going to run concurrently with each other. Count 1 is going to run consecutive. That means after counts 2 and 3. That will be 20 years to serve 1 month, with the balance of 9 years and 11 months on probation, and the remaining 10 years are suspended. It's a special condition of your suspended sentence that you obey the law and that you successfully complete drug court.
Okay.
It is a special condition of your probation that you complete drug court, that you stay away from the Chevron on Metropolitan Parkway.
Most definitely.
And you have no contact with Mr. Williams.
Yes, I won't.
Okay.
I won't.
And Ms. Nix, I'm not forgetting about the officer, but the only kind of contact they're going to have, she'd be in a uniform, and it's not going to be particularly consensual to begin with. So we'll just focus on Mr. Williams. I think I've covered everything there. Count 4 is being dismissed. Ms. Rios, anything else on behalf of Mr. Glass?
No, Your Honor, thank you.
Okay. And I don't have any petitions to revoke anything. It sounds like maybe Mr. Glass dealt with the revocation as a result of this arrest. I have no idea what's going on with that 23 SC sentence that was 15 to serve 5, and then do some ITF. My recommendation to probation is going to be to roll all of Mr. Glass's other cases into drug court so that everything is riding on drug court. That means that if Mr. Glass quits drug court prematurely, he's going to face probation consequences in all those. But in some ways, it doesn't matter. This case will handle it and cover for those other things. Ms. Nix, anything else in Mr. Glass's case?
No, sir.
I appreciate you and the state giving him a chance in drug court, but I agree with you that that's sort of his last best hope. And if drug court doesn't go well, that it will get pretty complicated pretty quickly. Ms. Nix, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Rios?
Yes, sir.
Mr. Glass, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right, we'll do that. Thank you. Ms. Evans, Officer Evans, do we need to give him reporting instructions, or that'll happen through drug court?
Your Honor, just in case something in between time, is it my understanding that Mr. Glass doesn't currently have a set address?
That's correct.
I think that's right. You don't have a address where like you get mail or a place. We're going to help you find housing, but there's not a home you would go to if you were released.
Okay.
Is that correct?
Yes.
Okay. Yes, ma'am.
Thank you, Your Honor. Mr. Glass, you're going to report to the Atlanta Probation Office. Are you familiar with that location?
It's Memorial. Is it Memorial Drive?
276 Memorial Drive. Yes.
Yes,
You're
ma'am.
going to report within. Oh, okay. You're going to report within 24 hours of your release.
Yes,
Failure
ma'am.
to do so may result in a warrant for your arrest. Do you understand?
Oh, I'll be there.
Do you have a good contact number? Somebody we could call, if anything.
Not right now.
Brother.
Not right now. Not right now. It's
Okay.
kind of hard for me.
Understood. Just make sure you report within 24 hours, okay?
I will, ma'am.
Good luck to you. Thank you.
Thank you, ma'am.
All right.
Thanks, everyone.
Thank you.
That's it.
Thank y'all so much. Y'all have a blessed evening.
All right. Can we do Mr. Gibson?
Yes.
And as for Ms. Hayes, I talked with Deputy Gordon, and he's fine leaving the courtroom as the space where a conversation happens. So I guess we start with that, and then if that results in Ms. Hayes being in a position to take a plea, we ought to do that. So when we're done with Gibson, I'll go, and I will come back, assuming we find Mr. Ross. We may deal with his plea, and then we also might deal with Ms. Hayes. Mr. Ross is back in Fulton County, but being processed. So he will be on a calendar tomorrow, and see if you prefer Zoom or in person. I have people coming over because it's drug court, so we can have Mr. Ross on the bus. Sorry, 1 second. So just work with Ms. Nelson about that. Oh, I'm now being told afternoon at 3 p.m. Hope that works for you, because that's when it's happening. Okay, cool. Thanks, Ms. Nelson. All right, but you are Mr. Gibson.
Yes, sir.
This is 24 SC 003567. Mr. Gibson, Ms. Rios tells me you're ready to enter a plea. Is that right?
Yes, sir.
Okay. And Ms. Nix, are you okay handling this? I think Ms. Willingham, I don't.
Just so everyone's aware too, the agreement was also a probation revocation.
We're handling that also?
Yes.
Okay. As long as you give me the number once we get into it, I'll look at that. All right. Mr. Gibson, in a moment, Ms. Nix is going to put you under oath and then ask you some questions. You need to answer those truthfully. You also need to let me or Ms. Rios know if you have any questions, okay?
Yes, sir.
All right. When you're ready, Ms. Nix.
Oh, thank you, Judge. Mr. Gibson, please raise your right hand. Do you swear or affirm that any statements or testimony, you got to keep your hand up. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, now you can put your hand down. Please state your true, correct, and legal name.
Jabari Antoine Gibson.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 41 years old now.
How far have you gone in school?
My last grade was completed was the 10th.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, battery, family violence, subsequent conviction. Count 2 and 3 are cruelty to children in the 3rd degree.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak? Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for purposes of the plea.
Mr. Gibson, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court?
Yes, ma'am.
Count 1, state recommends a 5-year sentence that you serve 6 months with the balance on probation. Counts 2 and 3 serve 6 months to run concurrently with count 1. Special conditions are no contact with the victim, complete the family violence intervention program, complete 60 hours of community service, submit to a substance abuse evaluation and follow any recommendation, no drugs or alcohol, and no weapons.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
Judge, does the defendant still have his final plea rights?
I think so. Let me look at, oh, yes.
Yes, okay. Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
Yes, ma'am.
Do you understand that your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Guilty on the alpha.
Are you pleading guilty because you've decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes, ma'am.
How do you plead to the charges of battery, family violence, subsequent conviction, and 2 counts of cruelty to children in the 3rd degree in indictment number 24 SC 003567?
Guilty on the alpha, man.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for the felony, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about January 20th, 2024, officers were dispatched to 2980 Jonesboro Road Southeast, apartment 353, regarding a dispute. Officer King spoke with Bernithia Anderson, Bernithia Anderson, who was the 911 caller. She informed Officer King that she was at home doing hair, and Jabari Gibson, who's the father of her child, was sitting on the sofa. After her client left, Mr. Gibson seemed upset and began questioning her about another male she was calling. Mr. Gibson grabbed her by the shirt and headbutted her, busting her lip. When she picked up the phone to call 911, Mr. Gibson fled the location. Mr. Gibson lives at the location on and off and is the father of her youngest child. That child was asleep during the altercation. Miss Anderson's 2 older children, ages 7 and 5, were awake and witnessed the incident. The surrounding area was canvassed with negative results. Anderson positively identified Mr. Gibson by a driver's license photo, and in 19 SC 167167, Mr. Gibson was convicted of 2 counts of family violence battery.
Can you say that case number again?
Yes, 19 SC 167167.
Is that the case that's still open on probation?
Yes, that's the one that we had an agreement to the 5 serve 1, revoke 6 months for that too.
Okay, we'll get Officer Evans's info on that in a little bit. Okay.
Ms. Willingham has been in touch with Ms. Anderson, who verified the facts of the assault, and said that she is tired of the physical abuse, but does not want to see the defendant in jail, but does wish for him to stay away from her.
Okay. Now they have a kid together, it sounds like. So I guess we'll need to navigate how Mr. Gibson would be able to see the child. But we'll get to that. Anything else, Ms. Nix?
No, sir.
Okay. Ms. Tyson, last plea of the morning. Do you have any criminal history information on Mr. Gibson?
Yes, Judge. We have 36 arrest cycles beginning in 2001. Last arrest was Fulton County, June 21st of 2024, and that was for a violation of probation. It looks like he has a couple pending. I'm not really sure. I think maybe transferred from state court, but it's a battery family violence from June 21st of 2024 with no disposition listed. And then there's also a Powder Springs arrest from June 12th of 2024 for willful obstruction. There's no disposition listed for that case, possibly pending. He has a DeKalb County arrest from November 23rd of 2022 with simple battery, no disposition listed for that on the GCIC. And he has another, a second arrest, I guess, for November 23rd of 2022 out of DeKalb County. Driving while license suspended, willful obstruction of law enforcement officer, cruelty to children in the first degree. It looks like that's pending. There's no disposition listed on the GCIC for that case. And it looks like he had, two felony convictions outside the 10-year period. One for theft by receiving stolen property out of Fulton County. The second was out of DeKalb County for by receiving stolen property as well. And it looks like he had a total of, five violations of probation and an FTA from, 2019 and 2015. And it looks like GCIC has a couple active warrants on it. So one out of Decatur for a failure to appear. That warrant was signed September 25th of 2023. He had a probation violation warrant out of Atlanta and a simple assault warrant out of Atlanta that was signed February 3rd of 2024. Nothing to add, Your Honor.
Wow, that was a lot. Thank you. Officer Evans has forwarded me the petition that Judge Leffridge, my next door neighbor, signed in the 19 SC case. It lists a whole bunch of violations. Most of them are not doing a family violence intervention program, but the capstone of them is this arrest in this case. So I think we can combine the two. Ms. Rios, what do you want to tell me about Mr. Gibson and his, he's got a lot going on.
Yes, Your Honor. He's 41 years old. He has 5 sons, ages 14, 12, 8, 3, and 1 years old.
So we got one guy with 5 boys and one guy with 15 girls. Mm-hmm. All right.
And he works for Gray's Lawn Company. So I understand how this case looks. I did receive a video from his son of the victim actually charging at him with the knife. It seems like there's an ongoing back and forth, and that's why I think the best.
Meaning Ms. Anderson charging him, not in this incident, some other incident.
He said, there's no timestamp on the video. I showed it to Miss Willingham and we couldn't verify the day.
Yeah.
But, he's saying that it was that same day. So we're not sure. It seems like there's an altogether toxic relationship between them two.
So staying away is good.
Yes, very good. He did try to sign up for the class. As far as the class about the probation revocation, he said they needed a police report. He was asking, he was trying to get in contact with probation to get that, and she never got back with him. So he said he did attempt to do the class, but he needed some further documentation that he never got, and that's why he wasn't able to do it. He has no problem with the conditions and the community service and all that. I think 5 serve 6 months, me and Miss Willingham talked, she talked to the victim. This is what we agreed on. And so I'm asking that you go along with the recommendation. He did want me to ask for county time. I did tell him that you don't really have control over how that works. But I do want to request that. And he also requested that he get into Pat. I did email Pat to see if they can help him. His thing is that he just needs to stay away from women, period, or certain type of women. He says that he wants to have some housing separate from that. So initially, his brother had been reaching out to me. He believes he could stay with his brother. And then in the meantime, I'm going to be looking for housing for him through Miss Ross and with the PAD. And hopefully with those two things, we can get him a situation where he doesn't have to, stay with women for housing. That doesn't seem to go well for him.
Okay. You're not blaming the women, are you?
I am not blaming the women.
All right.
I'm saying there's a volatile situation.
It's a bad combo.
Yes.
All right. Sounds like it's men for you from here on out, Mr. Gibson. So Levitas, am I pronouncing that correctly? This would be Ms. Anderson's kids. There's Legend and Levitas. Those are her Levitas. That's not Levitas is not your son. Legend is not your son. Ms. Anderson has a third kid who is your son.
2-year-old Lemire.
Name?
Lemire.
Amir?
Lemire.
Lemire.
Lemire, yeah.
Okay. All right. So Levitas and Legend, not your biological kids, but Lemire is through Ms. Anderson. You realize if you have to stay away from Ms. Anderson, which is what I think is a good idea, then you're not going to be able to see Lemire. And if you need to see Lemire, you need to have some neutral third party. I'm making the person up, but her aunt, where you would contact her aunt and say, hey, how can I see Lemire? And the aunt would do that. But you can't be calling Ms. Anderson saying, where's my kid? That's where we are right now.
I'm cool with that, Jerry.
You're cool with that. Okay. That's what I wanted to hear. All right. Well, I find that there's a factual basis for your plea. While you were on probation for a case involving family violence battery, there was another family violence battery. I also find that your plea is knowing and voluntary. That means you've understood what we talked about and that no one is forcing you to enter this plea. Your plea is an offered plea, which means you are telling me it didn't happen exactly like the state said it happened, but I, meaning you, still want to move forward with the case. Is that correct?
Yes, sir.
Okay, then I'll accept it as an offered plea. I'm sentencing you under the Probation Options Management Act, which means that while you're on probation, in this case at least, if you have a technical violation, let's say you miss a meeting, you don't have to come see me. Probation will work with you on that. But if you violate a special condition, any contact with Ms. Anderson, you get arrested for something, you don't do your family violence intervention program, that comes back to me and we'll work through the consequences. So Mr. Gibson, I am going to sentence you on count 1 to 5 years to serve 9 months with the balance probated. Counts 2 and 3 will both be 9 months to serve. Those will run concurrently with count 1. Special condition of probation number 1, no contact with Ms. Anderson. Don't call her, don't write her, don't do something online about her. Number 2, you will have 30 days after you're released. You're not gonna get out right away because you got a little time to serve here and you apparently have warrants in 2 other places. But 30 days after you're released and you start your probation, you have to start the family violence intervention program. You can't finish it in 30 days because it's a bunch of classes. But you got to be up and running within 30 days. You'll have to complete 60 hours of community service submit to a drug and alcohol abuse evaluation. And if that professional, usually a medical professional, says, hey, Mr. Gibson should go to AA classes or get some counseling, that treatment will be part of your probation. I will waive your probation supervision fees for the first 2 months while you get up and working again. I'd love to recommend PAD, but I actually can't do that because PAD won't take you if it's a condition of your sentence. PAD has no strings attached. They will take you because you walk in. But if I say you have to walk in, they'll say, we can't help Mr. Gibson. It can't be a condition of any sentence. So go see PAD. They do amazing things. They might be able to help you with housing without women, but I cannot make that a requirement of your probation. Let me finish what I'm going to propose we do, and then you and Ms. Rios can talk, because you can say, no, thank you. My sentence is a little bit higher than what was negotiated. I think it's still a pretty reasonable sentence given what you've been into and up to over the last couple of years. But you have the right today to say, I was willing to take 6 months. I'm not going to take 9 months, but hear me out. In your other case that's open, the one that's probation with Judge Leffridge, where there's a warrant for you, 19 SC 167167. As a result of your plea of guilty in this case, and your arrest for this case and all those other things listed in the petition, I will revoke 9 months and reinstate the balance. That'll run concurrently with, at the same time, this sentence. And I forgot to mention this, you get credit for all the time that you've been in connection with this arrest. So you've done a chunk of the time that will get you towards 9 months. I think that's a reasonable outcome for someone with 36 cycles, 5 probation violations, active warrants, and just coming off of a case where you were supposed to do family violence intervention and you hadn't started that yet. But you don't have to agree with me. You and Ms. Rios should talk, and you can say, Judge, I was willing to take 6 months. I'm not going to do 9 months. And then we just reset things and like, all right, I'm going to see you in December for your final plea. You can do the math about whether that's getting close to 9 months anyway. So you two talk and let me know what you want to do. It looks like you brought in some serious support, Ms. Nakes.
Just in town for the game, Judge.
Oh, the game was last night. Do you know that was what they call a scorigami? There's never been an NFL game that ended 32-19. It's the first time ever there's been an NFL game. It's the 1,080 something unique score in a game. But there'd never, if it had been 32-13, if they hadn't scored that last touchdown, there'd been because 32 is a weird number to get. And 19 is kind of also. So 32-19 has never been an NFL game with that score. Me neither.
That's such a good trivia fact.
It is. And I learned a new term, scorigami, a unique NFL score. Probably won't have another one this season because with 1,080 something options, and mostly it's 21-7, that kind of thing. Like, that's a score boring. So. Well, they went for 2 points. Yeah. But they must have maybe had 2 field goals and a touchdown because that gets you to 13. So they had 2 field goals and a touchdown. And then they scored another touchdown, 6, went for 2, didn't make it.
Your Honor, he would take it. He just wants to, I'm not sure if you have can put that in the order, but he wants to make sure it's in the jail. He doesn't want to go to prison.
So Ms. Rios is right. I don't control a whole lot of that. What I can tell you is that the sheriff's office tends not to send people down to the Department of Corrections when there's not much left in the sentence. So if it's months left rather than years. If I were to sentence you to 5 years, you'd be going to the Department of Corrections. I didn't, and so I can, make that recommendation, but I'm not the boss in that space, okay? So you've got a better chance than most that you'd stay here. Though I'll tell you, plenty of people don't want to stay here. They want to get out of Rice Street, but I'm going to respect your preference and we'll see what happens, okay? All right, that'll be the disposition. Let's see if Officer Evans has anything she needs to add.
Nothing further, Your Honor, other than reporting instructions.
Okay, let's do that.
Yes, Your Honor. Mr. Gibson, what is your current address?
2591 Etheridge Drive, Atlanta, Georgia.
I'm sorry, 2591 Etheridge
Drive, Atlanta, Georgia, 30318, apartment A314.
Say that again.
A314.
A314.
Yes, sir.
A314. You have a good contact number, Mr. Gibson?
Not right now because my phone cut off, so I couldn't give you a contact number.
Mom, cousin, sister, brother, uncle?
I can give you my brother's number.
What's his number?
678 600 0768.
0768.
Yes, ma'am.
And what's his name?
His name is Kelvin Williams.
Kelvin Williams. Okay, you're going to report to the Atlanta Probation Office. Are you familiar with that location?
Yes, on Mitchell Street.
On Memorial Drive?
Yes, ma'am.
Okay, you're going to report to the Atlanta Probation Office within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
Good luck to you. Thank you.
All right.
All right.
Thank you.
Oh, we didn't talk about signing. Ms. Nix, can my office sign the indictment for you?
Yes, you can sign my name on behalf of Ms. Willingham.
Okay, it's a lot of on behalf of. And Ms. Rios, can we sign for you?
Yes, sir.
And Mr. Gibson, is it okay if we electronically sign your name on the indictment?
Yes.
Great.
Yes. Is there any kind of way? Why they don't give you papers anymore? You used to get copies of what you done signed for.
So Ms. Rios can figure out a way to get them to you, the indictment. I don't know why you need the indictment, but you're certainly entitled to it. So I'm not saying no. It'll be, and your sentence will also be put in the docket, but not for probably another few hours. And we're not going to keep you up here for that.
Okay.
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 All right.
All right.
Thanks. All right. I am going to end part of this. Goodbye.